that was a full nationwide preliminary injunction, just as ours is. But of course, it's subject to appeal, and I think that the main difference is that the record is different, given the fact that the parties are different in the two cases, and of course the record is going to be different. Our declarations are, as I indicated, extremely comprehensive as to doctors, as to the Planned Parenthood clinics, and as to the effect on all 21 states. Each of our states has provided declarations. So we feel that we have a very strong record. I can't speak to the record in the Washington case. I'm sure they've done an excellent job. My colleague Bob Ferguson is fantastic, as we all know. And that case, of course, it was only Washington is the only state, just as California is the only state. But there is an organization, you'll have to tell me what it stands for. It's called NIFRA. That is a co-plaintiff in Washington, and that encompasses a lot of the family planning clinics around the country.
Okay, got it.
This ruling was pretty scathing of the proposed rule change, and went so far as to even say that Judge McShane believes that the states will prevail on this lawsuit. What did you think when you got the written opinion going through it?
Thank you for the question. Well, you know, a preliminary injunction does have to has to reach certain thresholds before it can issue. And the first one is that the plaintiffs are likely to prevail on the merits, which means we haven't won the case. We still have to go on and present our case fully, but we are likely to prevail, and that's why I said that it appears that the judge is satisfied that the conduct is illegal. It also requires irreparable harm, a finding that there would be irreparable harm if the law were to go into effect on May 3rd, if the rule were to go into effect. And so I was a little bit concerned last week because the judge seemed to potentially maybe have some reluctance about issuing a nationwide injunction, but I think he just was being very cautious and careful and wanted to go back and consider all of what he had heard in the arguments. And I was feeling pretty good that at the end of the day he was going to see it this way, because there was really no way to say, you know, these states should not be gagged, and these states should be, particularly when we have doctors in every state and when we have Planned Parenthood in, I think, 48 out of the 50 states.
Could either of you speak to how the new HHS rule would have primarily affected a lower income women's?
Well, I think the short of it is that we would be extremely limited in our ability to provide resources to the providers that provide services to those women. Nationally, it looks at about 4 million women. In Oregon, probably thousands, but it would be for rural and low-income women wouldn't be able to access the full complement of reproductive health services. And it includes screenings for mammographies, gynecological exams, and it includes screenings for HIV. It obviously includes family planning services as well.
And I would just add to that the 12 Planned Parenthood clinics in the state provide 40% of the Title X visits in our state, so our not participating in the Title X program would be a huge barrier to access.